We're just waiting for the record to start. Thank you for your patience, everybody. In so many ways, we're beholden to technology. We got to make sure we are on the record, which we are. It is May 4th, 2026. Court will call State of Utah versus Meggan Sundwall, case 251-401-132. Counsel, good morning. Please note your appearances.
Lauren Hunt and Sandy Ness for the state.
Scott Williams on behalf of Ms. Sundwall, Your Honor. She is, of course, present.
Thank you. This matter comes before the court for purposes of sentencing. We all right? I am in receipt of a pre-sentence report prepared by Adult Probation and Parole. I've also had a chance to review the multiple victim impact statements filed in this matter, as well as the statements in support of Ms. Sundwall. Before we get started, I just want to tell to all the parties who prepared statements, I want to thank you for those, for taking time out of your life to give me a little more insight. I can tell the time it took for those to be prepared and the emotion and the thought that went into those. For purposes of today's hearing, this is how we're going to do it. We're going to hear from Mr. Williams first, and anybody from the defense that he wishes the court to hear from. Then we're going to hear from the state, and after that, then we can hear from Ms. Sundwall should she choose to make a statement. We all on the same page, counsel?
Yes, Judge.
Yes, Your Honor. You did not reference, were you able to review the memorandum that I filed? So the statements were filed separately and as protected. The letters on our side.
Uh-huh. Did you file your memo that same day?
Then the memo was filed a couple days later for a couple reasons, but it was indicated as accepted as a courtesy copy. It sounds like that might not have happened in terms of your review of it.
Yes.
And so
that was filed on the 30th.
It was filed later for a couple reasons, and it did contain attachment letters that had come in after
Yes.
the letters.
Yes, and I've had a chance to review those.
Okay, all right.
Yes, thank you. I was concerned you filed something just in the last day.
No.
So, that I didn't have.
No, I wouldn't spring, well, I might, but I didn't.
All right. Yes, I have had a chance to review that. Thank you. All right, Mr. Williams, we're going to start with you.
Judge, thank you. Should I approach the podium?
It's however you want to do it.
Thank you. I'm used to it, so I'll do it that way. First of all, I'll indicate to the court we have no objections to nor corrections sought of the pre-sentence report. Except maybe sometimes they'll get my name right and send it to me, but I got it from the government. So that record, I'm sure Your Honor wants made.
Thank you.
So I won't, as I try not to belabor any points made in a sentencing memorandum that you have been able to review. I will say, Judge, well, I'll preface with our presentation on behalf of Meggan Sundwall's sentencing. I believe centers around two themes in this case. A rather remarkable case, as indicated in the memorandum, insofar as the very course of the hearings leading up to the trial, and the trial itself gave this court information about people that very well may not come out in cases. I mean, it's just remarkable. You got to learn from an expert about the two main people in this case, right? And their relationship, and that it was, of course, comorbid, and it was had a result, and now there's a sentencing. So I don't think and I don't have a case where I have to present mitigation of the normal sort that you might see, a drug addict, or someone who was abused, or explain away a criminal history. And that's remarkable, and I submit in a case that results in this sort of conviction and sentencing. So, as I speak less about Ms. Sundwall and more about a few other features of the case. It of course doesn't mean whatsoever that we minimize in any way the importance of her as a person. And what we submit is a wildly aberrant sort of dynamic and situation and result in terms of her general character and her likelihood of recidivism and the need for any deterrence and some of the major philosophical features of a criminal justice sentencing. I think our features that we want to focus on and did in the memorandum are deliberation about whatever anyone thinks or even the facts at trial, the respect for what the verdict means and how that fits into a punishment scheme. And the collateral impacts and our argument that collateral impacts are not irrelevant. As hard as it is to, I mean, you cannot deny that collateral impacts result at a sentencing. They result from the actions of the defendant. That's true in every case, but it cannot mean that the collateral impacts are not therefore relevant. I submit, quite frankly, maybe more so in many ways. So it's a tricky dynamic, but we think that that theme serves the argument that Ms. Sundwall ought to be given the privilege of probation by Your Honor, a probation that could include more incarceration in terms of the retributive feature of our criminal justice system and sentencing. Because I submit that none of the others features support a prison sentence. She doesn't need deterrence. General deterrence is served for this kind of aiding suicide events by what's happened in this case, by it can ruin your life completely and cause you to spend years in a county jail. That would serve as a general deterrence, I submit, for this offense that the jury rendered. And it is easy for us in this state to talk about deferring to the indeterminate sentencing feature and what the Board of Pardon, it will be the Board of Pardons to decide how long somebody serves on the sentence. But my closest colleague, practically law partner, is actually a pro tem member of that board. It is not, the same as it once was in terms of utilization of matrices. They literally use the matrices now to entertain the first hearing structure. It used to be, I don't mean to lecture the court, I know you know these things, but it used to be, Cole, I think you're being summoned.
Cole, we need to get these parties seated. I'm sorry to interrupt you, Mr. Williams.
No, that's fine, I'm just helping out Cole.
We can't have people standing.
Can we scoot over a little bit, guys? Just
Go, Mr. Williams, I apologize.
You're fine.
squeeze in.
Go ahead.
So at the Board of Pardons, if Your Honor sentenced her to prison and is finished with your role in this case by jurisdiction, they'll set a hearing based on the matrix. Even in a case that is unusual, I submit, in terms of the jury verdict like this, the matrix is 9 years. If she goes to prison, could get a little less than that, but that is what we're looking at. And I think the interesting part of that is I'm urging the court to consider it because of in light of the appropriate retributive sentence of punishment as necessary, and what incarceration means in terms of that punishment, especially to this community, this family, her son, etc. And that's what I'm talking about, the collateral. Because I know we have principle of sentencing, the need for punishment, the role of punishment, also mercy. and mercy for the others. And Ms. Sundwall, everyone deserves mercy, but we have quite a large feature. My favorite, I shouldn't say favorite, because especially on television, but I'm very, very fond of a federal judge, Judge Winder, who has passed for a number of years. I was lucky enough to practice with him a lot through my career. And he said something once to me. He said, true justice, and this was in the context of a sentencing, true justice requires mercy, avoids excessive punishment, and ensures impartial deliberation, rather than yielding to political pressure or societal vengeance. He said this, and by the way, I'm not bringing that up because I don't think the court already knows that by any means. I just thought it articulated some of the features of this in particular. And I don't think that there is any pressure for social vengeance, but to me, in a way, that's the feature of punishment, right? It is pure retribution. It's appropriate and part of our system. He said this when the sentencing guidelines were mandatory in federal court. He had very little power and authority at sentencing to even put these things into practice, but he believed them, and they've always stuck with me. On the impartial deliberation feature, then, I think we just have to, with the sentencing, respect what the verdict means the jury found happened. And as I've argued in my memorandum, though that's manslaughter, and the legislature designated as such, manslaughter comes in a lot of packages. And meting out a just sentence requires consideration of the spectrum of culpability and the nature of harm and the reasons for it, its motive, etc. And I think what you saw in Ms. Sundwall's recitation from the pre-sentence report, that there's a role, acceptance of the role, and the role that she played in this process, and even that night, especially, of course, because that's when it ended. But for her role, Kacee may be alive. Even though the jury's finding was this, she was aided in not wanting, in an attempt to not be alive. So it's accepted by Meggan that she played that role. And it's about what the appropriate level of outcome, a level of offense. And I think, again, we are right down to imprisonment. Mercy feature, as I said, I think, of what Judge Winder said includes the rational or the collateral impacts on everybody. And I submitted in the memorandum, part of it is the way that we consider that at sentencing should include just knowing that empirical studies show that the devastation that prolonged incarceration of a family member, and then particularly a mother, and as I showed you in the studies, or attached in the studies, the mother of a child of the age that or is just critical and important. And if we can mete out the justice that's required in the form of incarceration that minimizes that length of that incarceration to what is necessary but sufficient to serve that retribution purpose, then we've done justice. I wanted to reference a letter, and it was submitted by somebody on behalf of the state. And what I'm gonna do instead of reference it directly is figure out that I think your Honor probably knows whose letter it was. That person, I've said it in open court, I said it during trial, and I'm imbued by it in this sentencing, is an extraordinarily remarkable human being. I'm honestly blessed to have been part of a case, and that person expressed to you in a letter of grace that I submit, Your Honor, probably never sees, rarely sees at a sentencing, especially of this court, and especially of how close a person is to the decedent, to Kacee, I'm sorry I used that word, to Kacee Terry. And so instead of directly referencing by name, I wanted to make that comment because I feel like, honestly, I could submit that letter and say nothing more. That's all I have to say at this point, Your Honor.
You wish to, other than the letters that have been submitted, do you wish to have anybody else speak?
No, everyone would like to. And everyone, as you know, and I referenced the memo, but you've seen it. And that's why I mentioned community in terms of collateral impacts. Notwithstanding the verdict, notwithstanding what was heard at trial, and it was not information that would shine a bright light, a great light on Meggan. They believe in her genuinely as a person and as an important part of the community. So I'm not speaking only of Porter, who's number one, or Mitch and their family, number two, but the community. And they're here, they understand and have had through this process, that their voices are heard by you through letters that they've submitted, and I appreciate your honor indicating to them that you've read the letters and you considered them, and I told every one of those people that would happen. There's no question in my mind. The goal was for her to have them speak to her as a person in their community, not to seek to pressure you a particular sentence. And then I guess I didn't say it, but it goes without saying, and I should conclude with, Your Honor, I believe, can fashion the just sentence here without committing Meggan Sundwall to prison. And that is now all I have to say, unless you have further questions.
I don't.
Thank you.
The state wish to be heard.
Yes, Judge. First, Ms. Kylie Clark wants to be heard by the court, and in addition to the other letters, she's the only person that will be speaking personally today. But the court received other letters on behalf of Kacee's friends and family. So I'll have Kylie.
Ms. Clark, do you want to come forward?
And Judge, she has some photos of Kacee that she would like your honor to view. I don't know the best place to put this.
Right there is fine. Ms. Clark, thanks for being here. What would you like me to know?
Just want to
If you can pull that mic down so we can make a good record. Thank you.
before I read my statement that I submitted, I'd just like to share a few thoughts and memories of Kacee. Mr. Williams did a really good job during trial of making my little sister look horrible. He made her look like an addict, a thief, somebody that most people chose not to be around. That's pretty hurtful and hard to hear from somebody that never met Kacee. somebody that's only gonna get a little glimpse of her life and completely destroyed her. Kacee did not deserve that disrespect. Most of the people in this courtroom are here to support Kacee or Meggan. Most of the people in this courtroom know both Kacee and Meggan. And most of the people in this courtroom care about Kacee and Meggan. The Randall and Sundwall family cared for Kacee. They would invite her to gatherings, bought her gifts, and treated her like family. They loved Kacee because they knew the real Kacee, not the one Mr. Williams painted a picture of. Up until her death, I don't remember a time in my life that she wasn't with me. We shared the same clothes, we shared the same friends, we shared the same classes in school. Shortly after I got married, I moved from Alpine to Springville. And she moved in a couple months later because we weren't used to being apart. She truly was my best friend and a part of my daily life. Our husbands both worked on the oil rigs and would be gone for weeks at a time, and she would often come and have sleepovers at our house so we could hang out and let our boys play. We celebrated milestones and heartache with each other. Mr. Williams stated that Kacee hated me and that our family hated her. When my husband and I started doing foster care and learned that we'd be adopting a sibling group of 3, Kacee was so excited. And she went through the process of getting licensed and approved to watch those kids when we needed a babysitter. And she babysat often. Why would someone go through all of the trouble for someone that they didn't care about? Kacee loved the outdoors. Each year, our whole family would go to Wyoming together for an antelope hunt. My Uncle Mark would fly in from Atlanta and we would all spend the week together. And that was something we looked forward to every single year. Kacee loved the sand dunes and riding on long rides in the side-by-side. If you really knew Kacee, you knew the only thing that she loved just as much as Bella was her music, and she had it playing 24 hours a day. Kacee had the best laugh. If you never got to hear it, you missed out. Her laugh was just like her, one of a kind. I could stay here all day telling you stories and memories about my little sister, because that's all I have. This is all I have left. Or pictures. I'm so grateful for all the memories that I was able to make. I'm appalled and disgusted to hear that the defendant claims on a court call looking for insurance money that she was best friends and practically a sister to Kacee. I'm sad that my sister was broken enough to consider her a friend, because that's not something that friends do to each other. The fact that anyone could put a price tag on a friendship in someone's life is disgusting. And I hope that that guilt is carried every single day. I hope as the next step begins, you think of how your actions and choices have completely destroyed your life, your family's life, your child's, your marriage, your job, your covenants, and you made to God, all because of money. Money meant more than any of those items. This day should have never happened. You had so many opportunities to do the right thing. We had talked so many times over the years when you'd reach out to me about Kacee's life insurance policies and her health. And I told you that she was not telling you the truth, but your greed got the better of you and you chose not to listen. I hope you miss the important milestones that your son is going to make and that your family is going to have without you. As you sit in prison, you remember that each and every day, that you made those choices and you deserve to be there. No amount of time in prison will bring Kacee back. This did not have to happen. I don't think I will ever be able to forgive you for what you've done to my family and Kacee's true friends. You do not deserve to call yourself a friend, and especially not a sister. Now, I will read the letter that I have already submitted. My name is Kacee Clark. I am the sister and only living immediate family of Kacee Lyn Terry. I will try to make this short and to the point. Today I'm asking you to please consider the maximum sentence possible for Meggan Sundwall's charges, with no exception for early release or previous jail time accounted for. Only God, Meggan, and Kacee knows what happened that Tuesday morning, but we do know for certain what happened that afternoon and evening. We know that at some point Kacee received a lethal dose of insulin, something that Meggan had encouraged, supplied, and offered multiple times to administer throughout their friendship. We know that Meggan had soda, candy, and access to adults who live with diabetes upstairs, and the knowledge and training from being a nurse to help save Kacee's life, but it was never given. No help was asked for. No life-saving measures to reverse the insulin was ever given, regardless of who administered it. Instead, Meggan sat for hours, watching my sister slowly and painfully die. Did she ever seek help? No. She canceled her dinner plans so she could stay there to check her blood and do whatever needed to make sure her plan was still in play. She did this without having written proof of a DNR, which to her seemed to help justify the cause. But never once did Kacee's heart stop beating, not until the night of August 15th. Nothing Meggan did, or I guess didn't do, required her to be unfaithful to Kacee's so-called DNR. In fact, she did the opposite, and she let Kacee sit and drown in pain, exactly what she feared most. That is murder. The nurse from the ICU said that if help would have been given, Kacee had a good chance of being here today. She had seen it in other patients. Not only did Kacee have to painfully die once, but she was kept on life support while doctors and nurses did everything they could to only have her die slowly and painfully again a few days later. I hope each day that Meggan is behind bars that she will sit and think of the noises and the sounds and the movements and pain while watching my sister die, because it haunts me every single day. Someone will clear their throat or make a weird noise, and that will trigger those horrific memories of watching my sister die. The part that bothers me the most is that Meggan reached out to me several times over the years concerning Kacee's health, life insurance, or funeral arrangements. In those conversations, I told Meggan that Kacee did not have an insurance policy and that she did not have burial plot in Alpine, and that Kacee was lying to her. Yet money is evil, and she only saw the dollar signs. Meggan took advantage of someone that was mentally broken, somebody that only wanted to be loved and be enough. If Meggan was a best friend and practically a sister, as she claimed to be to Kacee, why did she never seek help? She never helped Kacee investigate therapy, talk to a bishop, call the Chrysler helpline. She never told her she was important enough or worth living or discouraged suicide, because if Kacee was alive, she wouldn't get the non-existent money that she so desperately wanted. Kacee never voiced a desire to die, to me or anyone else, like she did with Meggan. The complete opposite, actually. She expressed growing happiness and excitement for future plans in her life. The only concern she had was when she thought that Meggan was poisoning her, and guess what? She asked for help, and I helped. I moved her out of the situation as fast as we could. That is what you do for someone you love and truly care about. You get them help. Meggan is a wolf in sheep's clothing. She's evil, deceiving, manipulative, and controlling. You're going to read and hear from many that will say the opposite of my description. In fact, if Kacee was alive today, she would have been one that written one just like them. Good people can make bad choices, and Meggan has shown us that. But regardless of how Christ-like or salt of the earth person you are, you still need to be held accountable for the choices and actions you make. Loving God, your family, or having a child does not mean you get off easy. It does not mean you get to go home to that family early, because you made it so Kacee could never go home to the family that she loved and who loved her. I have no doubt that Meggan and Kacee were friends. I have no doubt that the Randall family loved Kacee like family. She told me often how they would buy her gifts and include her for holidays. I was grateful to them because you can never have enough people around that love you. And not having much family left, I was grateful for that. Kacee's birthday's in a few weeks, the same day my son has chosen to get married. Instead of taking her out to dinner and having her with us to celebrate our special day, I get to take balloons to her grave. I get to sit on the ground and essentially talk to myself. We don't get to have holidays, birthdays, go on vacations or outings together. My kids don't get to hang out or be spoiled by Aunt Howie anymore. Kacee's death, the trial, the past almost 2 years have ruined my life. It has affected me physically, mentally, financially. It has ruined friendships, put a strain on my marriage and relationship with my kids. They miss seeing their Aunt Howie and playing with Bella. They worry about me because of all the stress and tears that have affected my daily life. It also has affected my job. Some days are too hard to even leave the house. Not only did Meggan take Kacee's life, but she also took a huge part of mine. My life will never be the same. Meggan's greed took away my little sister. My wish is that Meggan gets to experience that kind of pain for many years and that she will miss all the important milestones that her family will make. Weddings, graduations, funerals, family outings. Nieces and nephews will be born and she won't be there. The holidays that are meant to be celebrated with family, she will miss out on because I know me and my family will. Eventually she will get those back, but I never will. Meggan should not have been the one to decide that my sister died. No amount of prison time will bring Kacee back to me, but it will ease the hurt and loss I live with each day. Each and every day, knowing that she is paying for what she did and the choices she made. I am asking you today to give my sister the justice she deserves and to make Meggan accountable for the actions she made with the maximum sentence available, accounting for both verdicts of guilty. Thank you.
Thank you for being here.
She'd like to please come.
Ms. Hunt.
Thank you, Judge. This hearing is not about whether the jury convicted Ms. Sundwall of aggravated murder or lesser offense. Obviously, the jury has made its determination. This hearing is about something different. This hearing is about what sentence is justice, given all the relevant evidence before this court. And what actually happened here is far more serious than the sanitized version the defendant has presented in her PSI. Importantly, the court is not limited to the minimum version of this offense. The defense has tried to collapse this case into the bare elements of aiding suicide, which the jury did find and the state respects, but Mr. Williams has said that this form of manslaughter is in the lower echelon of manslaughters. The state ardently disagrees with that. Sentencing is not limited to the bare elements, and the court is entitled, indeed required, to consider any relevant evidence, including the full course of defendant's conduct, the defendant's intent, the harm defendant caused, and the circumstances surrounding the offense. Even the PSI itself recognizes facts beyond the aiding suicide elements, including defendant's prolonged involvement, defendant's encourage of suicide over years, 4, defendant's financial gain, and defendant's obstruction after the fact. This was not mercy. This was prolonged encouragement and facilitation. This was not a moment. This was not a single bad decision. This was a multi-year pattern. Thousands of messages actively and heavily encouraging Kacee to commit suicide. Statements like, someone, probably me, should stay with you and keep giving you doses so your sugar stays low and it will work. Defendant's offers to personally administer insulin. Even defendant bringing insulin into the situation in the years leading up to Kacee's death. This was not passive. This was active conditioning of a highly vulnerable person toward death, preventable death. This was not compassion. What happened on August 12th was not mere aiding either. It was controlled, prolonged, and calculated behavior of the defendant. Even if we strip it down to the day of the 12th, the defendant was alone with Kacee for approximately 10 to 12 hours. Kacee's blood sugar dropped from normal to fatal levels over time. Kacee would have been unconscious well before the final stages. And defendant continued monitoring blood sugar throughout that day, and that is undisputed. We heard testimony, and I believe that the defendant even acknowledges this herself in the PSI. I could be wrong about that, but undisputably, she would have had to be the one to be testing Kacee's blood sugar past a certain point because Kacee would have been unconscious. And the only reason she was doing that is to ensure that Kacee died. She would even searched, as presented in evidence, how low can this monitor go, while also searching for jewelry, flights, and beach vacations from her phone. She did not intervene. She did not seek or give help. She sat and watched for hours as Kacee suffered exactly what we saw in those texts Kacee told Meggan she most feared, drowning in her own fluids. That is not mere assistance or mere aid. After hearing all of the evidence, is there any doubt in anyone's mind that had Meggan not gone to Kacee's house on August 12th, Kacee would still be alive? Meggan went to Kacee's home that day knowing Kacee would not act without Meggan's presence. And Meggan went fully prepared to participate in achieving her goal, Kacee's death. That is sustained participation in death. We heard at trial, but I want to reemphasize it here, all of the defendant's actions that equal affirmative interference with rescue. This is where this case becomes unmistakably aggravating. She told the family not to call 911. She told Mark not to call. She told first she told her own father not to call because, there's this DNR. She told Mark not to call because there's a DNR. When Mark was insistent that he's gonna call 911, he said she came undone. She was so furious that her plan might go off path. She called Kylie to try to say, hey, there's a DNR, what 911 can't be called. She's spreading this lie. She's affirmatively interfering with all these people that are trying to rescue. A DNR that did not exist, and again, Meggan would have known that it did not exist. She claimed power of attorney that did not exist, and again, she would have known that did not exist. She withheld critical medical information from the paramedics, and she hid evidence. She deleted all the messages, or at least hundreds of messages that had to do with insurance, insulin, and suicide. This was not indecision. This was affirmative interference with any chance of survival. I want to talk about her motive because that's something that the jury, with their finding, they didn't have to account for it. It wasn't part of the elements of the manslaughter that they found. But nevertheless, there is significant evidence of it that the court can and should consider here. The defense narrative depends kind of on one thing, that this was an act of compassion, that Ms. Sundwall had been led astray by Kacee's lies, and that she was just trying to get her out of this miserable existence that she was living in. But the evidence contradicts that. The defendant believed she was the beneficiary of a life insurance policy worth up to $1 to $1.5 million. She was experiencing significant financial distress, and the texts bear that out. She said things over years like, if you dying would get me out of this mess, I would take it. After the death, as Your Honor heard, she searched for and called on the insurance policy. Kacee was not actually sick, did not have terminal cancer, and didn't actually need Meggan's compassion in that way, in the way of aiding suicide. It is not plausible that Meggan believed that Kacee was suffering in the way and to the degree that Kacee's lies could have represented to her. Because again, Meggan is a trained nurse. This is not mercy. Mercy, as Kylie pointed out, would have been calling Kacee out on what Meggan knew, had to have known, were obvious lies about her health and condition. Mercy would have been suggesting mental health resources. Mercy and compassion would have been reminding Kacee of all that she had to live for, telling her that her life mattered. Instead, we heard over and over and over again, what do you have to live for? Everything you have is on the other side. Run to the other side, Kacee. What do you have to live for? What Meggan has demonstrated here is opportunism aligned with death. I want to talk about the PSI because what we see in there from the state's perspective is minimization, not accountability. The PSI matters here because it shows who Meggan is right now. And what it shows is minimization. Number one, minimization. She frames this as believing in cancer, helping a friend, a tragic mistake. But again, no cancer, and even if she did believe that cancer at some point existed, her training as a nurse would make the extent of what Kacee was saying was going on with her health wholly unrealistic, absolutely unbelievable. She was getting vitals not compatible with life. Situations that she would have known are not realistic, not how the medical system works, not how health works. She had years of involvement, encouraging death and ignoring the obvious falsehoods Kacee was telling her about her condition. And even APMP notes that there is denial and minimization as a barrier here. Number two, she has false self-presentation. She claims consistent employment and stability, but in reality, we know that she was fired for time card fraud. She's been in between jobs. I know that she was employed at the time of her arrest, but the time card fraud, I know the jury didn't get to hear about this, but it is significant here because, as the court knows, she was and continues to be in great financial distress. And as the court noted in its bail findings, when bail was originally addressed, that Ms. Sundwall has demonstrated extreme and illegal behavior when she's backed into a corner financially, when she's desperate, and that has not changed. If anything, it has gotten worse. Additionally, the defendant told the PSR investigator that her parents, quote, supported the defendant's decision to assist in ending the victim's life. That is false. Her parents testified that they did not know of the defendant's efforts to end Kacee's life. Her father testified that aiding suicide was contrary to his beliefs and what he understood Meggan to believe. Indeed, what he believed Meggan's character to be. I believe he was on the stand, and this is not verbatim, but he was very strong about it. No, suicide, even suggesting suicide, encouraging suicide, certainly helping with suicide, goes fundamentally against Meggan's character. This is an example of Meggan's attempt to justify and normalize her behavior and manipulate the PSR investigator. Number three, we see manufactured remorse. She does express remorse in the PSI, but again, just like she did when the cops kind of had her backed into a corner and had lies on her and said, no, we know, we've seen the text, you did something different. She only takes the level of accountability that she's pushed into. She doesn't ever take the full accountability for her actions, only to the degree that she knows, okay, I've been found out this hard, to this level. Okay, the jury has convicted me of manslaughter, so now I have to take accountability, just not one bit more for the manslaughter. And again, her conduct shows otherwise. We have a year of jail calls where the defendant has received, where she's attacking the victim. She calls Kacee a liar. She's expressing that she hopes Kacee gets what's coming to her in the afterlife. She's expressing hostility rather than accountability. This is not remorse. In fact, in the pro-criminal attitude category of the PSI, the concerns defendant expressed, we're all about her. The PSI reported that she was concerned about the impact of her actions on her ability to spend time with her child, and that she is experiencing emotional distress due to the loss of the victim. Even her so-called expression of remorse for the pain Kacee's death caused all the people in her life is framed as the pain that she will have to live with, not regret for causing a death of someone loved and cherished by many. This is strategic language at sentencing because, again, she's backed up against the wall and she knows the exact level at which she has to express remorse and accountability. It's accurate that Kacee was not always truthful. We heard a lot of testimony about that. The evidence showed that her misrepresentations centered on her health and were driven by a need for attention and connection. The defendant's own expert talked about that. And importantly, Your Honor has now heard from those who knew her best, Letters and Kylie here today, who have given the court a fuller picture of who Kacee was. She was a real person, a loved sister, a friend, a member of a family who must now grieve her loss. So yes, Kacee lied at times, but the evidence has shown that that came from a highly vulnerable state, exploitable state even. But she's not the only one who has lied. The defendant has also been untruthful, both about what happened and about who she is. She presents herself here as remorseful, as someone who acted out of character, but that claim is directly contradicted by the evidence. Again, her father tested forcefully at trial that encouraging suicide would be fundamentally inconsistent with the person she claims to be, and yet we see years of her doing just that. What the record actually shows is that Ms. Sundwall is capable of presenting whatever version of herself is most useful in the moment, whether to friends, to family, or now to this court. That is not accountability. That is continued manipulation reframed as remorse. The defense has alluded to her having a strong support system in the community, points to family and community support, but the court should consider these are individuals who the defendant herself misled for years, who the defendant told false information about DNR and other authority that she had over Kacee's life, apparently. Individuals who the defendant ensured did not have the full picture of Kacee or the defendant's own actions. Support based on incomplete or inaccurate information is not the same as informed, meaningful accountability support. Judge, this is exactly the kind of case where guidelines require prison. Even the PSI recommendation is imprisonment. The aggravating factors under Form 7 are actually overwhelming. The PSI checked the box for a death caused, but I would argue that the following should also be checked: prolonged conduct, extreme depravity, and also there's an others catch-all category that here should also include the deception and obstruction and the financial motive that defendant had here. Mr. Williams has talked about the defendant not having criminal history. That's true. She doesn't have a prior record. Perhaps this would be more compelling in a different type of case or crime. But this, again, was not a spontaneous or impulsive offense. This was planned over years, reinforced through thousands of messages, and carried out in a controlled, prolonged way, and then covered up. A lack of prior record does not mitigate conduct that is this deliberate and this sustained. If anything, it shows this was not situational, it was chosen again and again. The jury also convicted her of obstructing justice, and I would argue and ask that the court run these consecutively. Under Utah Code 76-3-401, subsection 2, when making that decision, the court shall consider gravity of the circumstances of the offense and the history, character, and rehabilitative needs of the defendant. And again, although the defendant doesn't have a criminal history here, her history with Kacee alone demonstrates her character and justifies these offenses running consecutively. Your Honor, prison is the only sentence that accomplishes justice here. Probation in this case would communicate something fundamentally wrong, that a person can encourage suicide for years, over and over and over again, facilitate it, watch it unfold over hours, check blood sugar to make sure that it's happening, affirmatively block rescue in a number of different ways, conceal and delete evidence, and then minimize it, and still avoid prison. That is not accountability, that is not a deterrence, and it is not justice. True accountability requires full recognition of the harm, full acceptance of the responsibility, and she has done neither. Protection of the public. This case reveals, again, the defendant's calculated thinking, the defendant's ability to manipulate not only the victim, but her own family and those around her, the defendant's willingness to override human life for personal interest, And all of this was done by a licensed nurse. That's not addressed by probation. She was a nurse, she was caring over the course of this case. We've heard, she's a caretaker. She likes to caretake, and Casey's the one that took advantage of her because she just wanted to help. And they rely heavily on her identity as a nurse throughout this case, but this cuts the other way. Her training means that she understood what insulin would do to a non-diabetic like Kacee. She recognized the signs of hypoglycemia. She knew exactly when intervention was necessary. And instead of using that knowledge to save a life, she used it to monitor and ensure Kacee's death. This was not a failure of knowledge. This was a misuse of knowledge. I want to talk about the harm to her child, which the defense, Mr. Williams, emphasized heavily in his memorandum. He devoted significant attention to collateral impacts on the defendant's family, primarily her young child. Those impacts are real, and the state, I do not want to minimize those effects that her incarceration will have on her family, especially her child. But they cannot be allowed to overshadow the central fact of this case, that a life was taken unnecessarily. Children can be impacted by incarceration of a parent, of course, but they are also impacted by the absence of accountability for serious harm. The impact on her child is not the product of the justice system. It is the product of the defendant's own conduct. If existence of a child were enough to avoid prison, similarly situated defendants with children would be categorically shielded from meaningful accountability, and that is not the law, as the court well knows. The defendant is selectively invoking her role as a mother now, after years-long conduct that showed blatant disregard for others' lives and well-being. This argument asks the court to reduce accountability based on a responsibility the defendant did not prioritize at the time of the offense. Even in the years leading up to the offense, she was not prioritizing her role as a mother when she was heavily encouraging and offering to assist and ultimately facilitating Kacee's death. Defendant's reliance on her child now risks becoming a manipulative appeal to sympathy rather than a legitimate mitigating factor grounded in her own conduct. Sympathy cannot displace accountability. Collateral harm does not eclipse the primary harm. The law does not allow us to singularly weigh one child's hardship against another person's life. I want to talk about deterrence, because Mr. Williams also said that a prison sentence wouldn't act as deterrence here. But this case sits at a dangerous intersection of medical knowledge, vulnerable individuals, and influence and control. If this case does not result in prison, the message is that this kind of conduct is negotiable. It is not. The public should not be given a message that this behavior, even if couched in mercy or believed to be mercy or compassion, does not result in the punishment that is warranted. I want to talk about moral culpability. Even under the jury's verdict, encouraging a mentally vulnerable person to die, facilitating that death, and ensuring it's not stopped is among the most serious forms of manslaughter, not the lower echelon. This was not a lapse in judgment. It was sustained, it was intentional, it was self-serving, and it was concealed or attempted to be concealed. And 1 year in jail and probation does not even begin to account for that. Ms. Sundwall needs the time prison affords for true accountability and for true remorse to take hold, to reach her and to sink in, and only then will justice be served. Defense argues she's a good candidate for probation, but probation requires insight, honesty, and full acceptance of responsibility. Without those, probation does not and cannot function. The PSI, again, itself notes denial and minimization as active issues. You cannot rehabilitate conduct that the defendant does not fully acknowledge. Judge, all of the mitigation presented, the lack of record, her profession, that she claims is stable, her family, her stated remorse, it would carry weight. It might carry weight in a different kind of case, but not in this one, because those factors are directly contradicted by the duration of her conduct, the level of her control, the deception of defendant that's involved here, and the ultimate outcome and price of it all, Kacee Terry's life. When the mitigation is weighed against the full scope of what occurred, it does not reduce culpability, it highlights it. And for that reason, probation is not appropriate, a prison sentence is. Justice in this case demands a prison sentence, and consistent with APMP's recommendation, that is what the state is asking this court to impose. We also asked to set a restitution hearing to come to final numbers on that. We do have some documentation that I'll get to Mr. Williams. And we also have filed, and we'd ask the court to sign a continuous protective order on behalf of Kylie and Jim. Thank you, Judge.
Thank you. Ms. Sundwall, you have a right to be heard before sentencing. Would you like to be heard?
Before that happens, may I respond briefly?
You may.
And the reason I'm asking is come on up, Meggan, is not to re-argue my case, and I'm not going to talk about any of the facts. You heard a full trial, so. But one of the challenges with references to the pre-sentence report is that document is not public. And as you know, Ms. Sundwall made a statement in that document. And she didn't call this a mistake. And she didn't focus only on herself. And I think it's important that I speak to that. That she said, I'm extremely ashamed to admit I actually encouraged her to end her life. But for the role I played, Kacee might still be alive today. I will also have to live with the pain that my role caused in Kacee's death, and that it caused the people in her life, especially her sister Kylie and Uncle Mark. And I violated my role as a citizen when I lied in the investigation. So I just want to make public that is the position. I also want to point out that when the pre-sentence report is created, it does reference recommendations, but the guideline matrix in this is prison. So that is unremarkable that pre-sentence report recommends prison. That would be the presumption. And there is an opportunity specifically for APMP to present an argument as to why they're making a certain recommendation, whether they're aggravating and mitigating factors, and they did not mention anything that you just heard from the state. It simply was a matrix recommendation. So I want to speak to that. I want otherwise to respond. I respect that what you have set up is the order of communication and representations to the court. So because of the reference to that document that I asked to do that. I think Sundwall does want to speak.
Thank you. Ms. Sundwall.
Thank you, Your Honor. I'm grateful for this opportunity in open court to apologize, especially to Kacee's family for what happened. As I said in my statement, if it wasn't for my role, Kacee likely would still be alive. She was loved by so many, I think even more than she realized. Friends, family, coworkers, associates. And that her death hurt a lot of people. My role hurt a lot of people. And that includes my family and my son as well, of course. But whether I believed that she was suffering so immensely or not, encouraging her and supporting her in committing suicide was morally wrong, and I'm so sorry. I know these are just words and they can't bring her back, but I am truly so sorry for the role that I played in her death. I wish I could take it back. I'm just so sorry.
We have to put it unless the court sees.
Thank you. This matter does come before the court for purposes of sentencing. And again, referencing all the parties who have submitted statements, and to everyone involved, the gravity of the decision that I have to make in something like this is not lost on me. And the effects on all involved are just profoundly immense. I understand that. I want to talk a little bit about what I've read in some of the statements and what is contained in the pre-sentence report. First off, I want to single out a statement that Mr. Williams did from Kacee's uncle, Mr. Farnsworth. He testified at trial. He was on the stand for quite a bit, and he was very familiar with the situation and lived in the same house with Kacee. Mr. Farnsworth, I want to tell you I appreciate your understanding of our system and how it works. And in particular, I appreciate the empathy you've shown toward Ms. Sundwall's family. While acknowledging your own family's continued suffering. Those are not statements I see every day. So, thank you. Also from the statements, it's clear that Ms. Sundwall, you are supported by many, many, many people. It's only going to help you moving forward. In trial, we were shown an exhibit that was a photo that was next to Kacee's pillow. And it appeared to be a picture of you and Kacee. And on the frame, it said best friends, or something to that extent. I'm not sure how a person gets to the point that you did with your best friend. From the evidence in trial, it really appeared to be an extremely dysfunctional relationship. And in reading the countless texts with talk of death and life insurance and suicide, and many of those texts that you received from Kacee, being a trained nurse, even in context, would be just considered unbelievable. I want to talk now about something I also don't see that often in this courtroom, in this kind of setting. In every pre-sentence report that's prepared, the defendant is given a chance to write a statement. And Ms. Sundwall, I want to read some of yours so everybody can hear. And your attorney's already alluded to or read some of those statements. But I want to read some of your statements. You specifically wrote, "Because I believe she was suffering so immensely, I did not discourage her from ending her own life. In fact, I am extremely ashamed to admit that I actually encouraged her to end her life. I have spent countless hours pondering on how I could have allowed myself to lose sight of my own beliefs, how I allowed myself to stray so far from the very core of my being, my principles, my character. But for the role I played, Kacee might still be alive today. I will have to live with that shame, the absolute regret, the overwhelming remorse at my role every day, every hour, every minute, every second for the rest of my life. Even more than that, I will also have to live with the pain that my role in Kacee's death caused all the people in her life, especially her sister Kylie and her uncle Mark." Ms. Sundwall, I appreciate your statement. It shows some self-awareness, and that's not something I always see. In fact, it's rare. hopefully this statement will help you in the future moving forward and help Kacee's family moving forward. Up to the point of Kacee's death, you, from what I've read, you appeared to live a life of service to others. Dedicated service to others. And in your statement, you indicated you don't know how you lost sight of that. And that is extremely sad and unfortunate. The balance in a matter like this between justice and mercy is a delicate one. It really is. But the fact of the matter is that a human being died. Kacee. She died too soon. And you played a key role in that death. As has been stated by both sides, this is a tragedy that never needed to happen. It just didn't. I can only imagine the suffering that Kacee experienced in those last hours in your presence. And the fear. And those last hours that she experienced in the hospital. And Kacee experienced these due in large part to your individual actions. It was a choice that you made. I truly wish the best for Kacee's family, and I ache for what you have been through and what you will go through. Ms. Sundwall, I also hope you and your family can find your way through this. Because unlike Kacee, you still get to live your life. And I truly hope you make the most of it. I really, really do. As I said before, the impact on Ms. Sundwall, you and your family, and Ms. Terry's family are just incalculable. As for sentencing, I have had a chance to review the pre-sentence report as prepared by AP&P. I will note for the recommendation that is provided by AP&P is one for imprisonment. And based upon the information and evidence before the court, that is what I am going to order. As to the count of manslaughter, a second-degree felony, I will sentence you to a term in the Utah State Prison of 1 to 15 years. As to the count of obstruction of justice, a third-degree felony, I will sentence you to a term in the Utah State Prison of 0 to 5 years. Based upon the circumstances and facts before the court, having been through or viewed the evidence in trial and reviewed the pre-sentence report, I am going to order that those counts will each run concurrent to each other. I will also make a recommendation to the board that you be given credit for time served. But ultimately, that's going to be up to the board. All I can do is make a recommendation. It will also be up to the board to make the determination of how much time you actually have to serve. I don't get to make that decision either. I can only impose the maximum, and the board takes it from there. But this is a case where prison is warranted based upon the facts and circumstances before the court. Ms. Sundwall, I want to tell you that your story doesn't end here. You're going to get out of prison, and you're going to live your life. And you will get to decide how 30 days to contest this sentence. I would ask that you consult with your attorney if you have any questions. The state has requested a hearing regarding restitution. Counsel, how much time do we need?
Probably just a few weeks.
Did you say how many weeks?
Just a few weeks, or whatever is convenient for Mr. Williams' schedule.
And Your Honor, I wonder, whatever we set whether the court would be agreeable to striking the hearing if the parties indicate to the court that there's
Of
no
course.
disagreement.
Of course.
I-
If we have a signed stipulation.
From what I've seen, I don't think there's going to be, but I don't know. Anyway,
Are we okay to do it via WebEx?
that's my second request.
The state's fine with that.
How
So-
about June 1st at 1 o'clock via WebEx?
That works for the state.
Yes, Your Honor.
I will also go ahead and sign it was a continuous protective order, Ms. Hunt, that was filed?
Yes.
A continuous protective order. Counsel, anything else we need to cover?
Not from the state, thank you.
No, thank you, Your Honor.
All right, I do want to thank everybody who's been involved in this process. It is not an easy one, and again, these decisions I do not take lightly. Appreciate everybody being here. We'll be at recess.